I'm also going to introduce Mattson Allen, who is a managing director in the transactional risk practice group at Marsh. Since the late 1990s, Matt has been an expert in the field of transactional risk insurance, responsible for advising clients on reps and warranties insurance, tax insurance, and other insurance products addressing contingent liabilities encountered in M&A transactions. Matt graduated from Lafayette College in Easton, Pennsylvania. I'm going to turn it over to you guys and let you guys take over. Thank you.
Thank you for that introduction. And I also want to thank you for showing up in person, those of you that are here, and those of you who are watching virtually. I hope you enjoy this as well, but you won't be able to receive these Bell Nunnally mini cookies that our Bell Nunnally elves were up all night baking. So as we planned for this event, we tried to think about how we could make this, less boring than a lawyer standing up here and reading a PowerPoint to you. And so we came up with the idea of both a lawyer and an insurance broker reading a PowerPoint to you to see how low we could go. So we hope we achieve our objective of not actually reading a PowerPoint to you, but having an interactive session and letting you know a little bit about reps and warranties insurance. And just as we get started here, just so we get a feel for the audience, I'm just curious, how many of you, just raise your hand if you're familiar with reps and warranties insurance and you've, in your practice, and you've encountered that? Awesome. I think it's, I was talking to Matt before this, and we both have been doing this for a while, our respective professions, and I think reps and warranties insurance, I think, is one of the largest, the biggest developments I've seen in the M&A corporate practice since, I'm going to go out on a limb here, since the invention of since LLCs came into being, which I remember as well as a young associate. So it's a big deal. It's exploded, as we talked about, it's exploded over the last 5 years or so. And it's, I think, as you'll hear from Matt, I think it's expected to continue to grow and become more of a mainstay in M&A practice. So, in essence, reps and warranties insurance, what it does basically, in essence, is it insures typically the buyer of a company from the breach of the express representations and warranties of the seller and the selling company under a purchase agreement. And so that's basically, it's an insurance product. That's basically what it does. And it's changed the way that M&A is conducted. And I guess, Matt, I know obviously in the United States, but I don't know overseas if it's...
Yeah, it's global as well. I mean, principally started here in the U.S., but also in Europe, Asia, PAC, basically all over the world for the most part. Some jurisdictions more challenging than others, but it is a global product. But, yeah.
So Matt, you want to speak a little bit about the development of RWI?
So in the late 90s, Marsh and another broker out there, we thought this was a really good concept for our private equity firms. I don't know if that's private equity firms. It just made a lot of sense. Private equity firms have assets. They sell those assets off, and reps and warranties, they have long tails to indemnities. Whether it's general indemnification or tax indemnification or fundamental indemnification, and so they had to keep these assets tied up as these indemnifications wound down. And we thought a good solution for that would be to put an insurance policy in place so that they could, not have these contingent liabilities. They could distribute their funds to their LPs and kind of wind things down and, obviously have the LPs realize those investments earlier. So it made a lot of sense from that standpoint. It took a little while to get, the M&A community to accept the policies, but what really started to get the traction there was private equity saw, they realized the risk management concepts of it, but what they really saw when it was in auctions, what they would do is you'd have 8 bidders that would bid on a company. Everyone would bid $100 million on a company. You'd have the traditional escrow put in place. You'd have the traditional indemnification cap. And our private equity firm would come to us, get an insurance policy to put in place, and not have that escrow or indemnification. And they sort of viewed that as their secret sauce to help win them bids in auctions. And so that's how they used it strategically. And then when they wound down that asset, when they were selling that asset in auction, they just reversed that process. So they went out and said, we're going to sell this company, and if you're going to bid on this company, then you're going to have to put rep and warranty insurance in place, and that's going to be your sole recourse. So as that cycle continued on and others realized that that was a way to be more strategic in auctions, the product really took off. So in terms of the makeup, and these are just some stats just to walk through, generally speaking, but today about 99% of the policies that we insure are for the buyer. It's just a more efficient process. I mean, the goal here is to knock out the escrow and the indemnification for the seller. In order to do that, if the buyer is the insured, the buyer goes to the insurance company if there's a claim or a breach and goes after the insurance policy and doesn't have to tangle with the seller. In the early stages, every seller, thought the product made a lot of sense just because they didn't want to put up the escrow and indemnification, but the challenge was getting a buyer to accept that in lieu of that escrow and indemnification. So oftentimes the buyer wouldn't accept that, so what we would do is put a seller in policy in place that would really sit behind that escrow indemnification in the event that the buyer had a breach of a rep and warranty. As the product has evolved and the buyers have accepted the insurance, there's no need to put the seller policy in place, so virtually all the policies that we do are insured for on behalf of the buyer. As I said, it started off as a private equity play. As time has developed, strategic and corporate buyers have been out there in auctions and so forth. So we've got a split of about 50-50 in terms of the policies that we place that are private equity versus corporate strategic. And then we'll talk a little bit about this later, but a makeup in terms of how the indemnities work on these policies. If the seller does have indemnity in a transaction, it's usually within the retention. The retention is pegged off enterprise value. It's pegged at about 1% of enterprise value. And so if the seller is going to provide indemnity to the buyer, it's usually within that retention at 0.5%. So seller has a 0.5% retention for the first 12 months. Buyer has 0.5% of that retention, and then after 12 months, that retention drops to 0.5%, the seller's released, and then the buyer has a retention for the remainder of the policy period. So a situation where the seller would not provide indemnity would be where the buyer would take that retention of 1% in its entirety. The seller wouldn't have any obligation. And just to give you a sense of how many deals go either way, we've got about 50-50 where sellers provide indemnity and those that don't. In terms of, there's not one certain industry that we focus on. We can essentially insure all of them. And just last year, the breakout of the top three, technology, manufacturing, and healthcare were the top three industries in which, put reps and warranty in place for transactions.
Thanks, Matt. I thought it'd be helpful to mention when we speak about enterprise value, just think of that as the purchase price, the sales price in the transaction. So even if you were selling a company for $100 million and you had $90 million of debt that was paid off at closing, which is, unusual, but anyway, even in that situation, the enterprise value would be $100 million, and because that would affect, that's what the buyer's paying, and that's affects the insurance amount. So what's great about reps and warranties insurance is it provides benefits to both sides. So, and as Matt mentioned, this is a recent phenomenon, and we're in the midst of a real development here, in particular over the last 5 years. So before reps and warranties insurance, typically, and today if you don't have reps and warranties insurance, typically when you're the seller, your reps and warranties will survive closing for somewhere between 12 to 18 months, and then you'll have fundamental reps, which basically survive for the statute of limitations or indefinitely in that case. And so one of the benefits to the seller is that Matt mentioned, sometimes you'll have what you call a walkaway deal where you don't have liability after closing. The policy will cover general reps and warranties for 3 years and fundamental reps for 6 years, although I just did a transaction where the seller had some remaining liability. The seller agreed before we got involved to a longer survival period than the policy was, and so we were able to get supplemental insurance to cover that, to bridge that gap. And just by way of background, a fundamental rep would, for those of you who aren't familiar with the term, would be something that basically, as the term says, fundamental to the transaction. Basically, that that you're in existence, you have authority to transfer the stock or the assets, what's ever being sold, that it's free and clear of all liens, and the basic the representations that you would think that give you the essence of your transaction. Another thing the sellers like is in a traditional transaction without reps and warranties insurance, your escrow could be anywhere from 10 to 15% of the purchase price. So on a $100 million transaction, you're looking at an escrow and a holdback of, in this case, $10 to $15 million. Whereas reps and warranties insurance, it's typically 1% of your enterprise value or sales price, meaning that if you had a $100 million transaction, your escrow would be $1 million, 1% of the enterprise value. And as Matt indicated, sometimes that's split between the buyer and seller. I seem to see more of that. I think it depends on the size of the transaction, but either that or the seller can have all the retention. I guess you could have a situation where the buyer's all the retention. Yeah, I don't see that as much, but I guess that could be the case as well, depending on how competitive the auction is or the bid is for the product. And as I mentioned, what's great, the sellers love it in the sense that you can have what's called a walkaway deal, and you don't have to worry about, when I represent sellers, particularly family businesses or closely held companies, you always can tell the seller that your walkaway deal, you don't have to worry about somebody knocking on your door in 10 years and asking for a check, and so that gives people peace of mind, and that's a great, with any insurance product, that's a great thing about insurance products is you basically insure around that risk and don't have that risk. It also protects the buyer in the sense that you have a huge insurance company that's standing behind that policy, whereas oftentimes the seller will take the closing proceeds and distribute them, or over time they could be sold or file bankruptcy or dissolve, and so this gives you deep pockets to go after for a long period of time, whereas in a traditional transaction that your collateral being the seller and you're buying the target company, if you're not buying the target company, could go away. And a big thing in how this whole reps and warranties, I think, that gave it its big start was the fact that that it makes a buyer's bid more competitive in the sense that you can tell the seller that, hey, we're gonna purchase this policy, and I guess depending on how competitive the situation is, I often see the premiums split. But a buyer, I guess, Matt, could really distinguish themselves by agreeing to pay for the entire policy. And we'll talk about the cost of that in a minute. And this is also really important, I think, the final point about the seller protection is, particularly with a small, lower middle market, family-owned business, closely held business, and particularly in a private equity transaction or a non-strategic transaction, they're buying the management team, including the seller, and so it's really awkward for a buyer when you buy a company and then you have a claim and then you're making a claim. You turn around and asking for this key management person, your CEO, the founder of the business that you bought, to write you a check. I mean, that just isn't that's not a comfortable conversation to have, and it can have negative repercussions to the business. So it avoids that, and it makes the seller almost align with you, right? Because particularly if they have rollover equity, they have rollover equity, and you're making a claim against the insurance policy, and they're an owner of your business as well. So they're, as opposed to being opposed, offended and opposed to the claim, they're actually on your side with making the claim because it's going to benefit them as well. Another situation where that's reps and warranties insurance is helpful is if you have, which was, I think, was more active earlier on, but not as active these days. It's sort of the reverse. But you have a company that's going, they're going public to private, and so you've got all these, public shareholders, and they're not going to want to. Obviously, they're not going to have any liability post closing, and it also gives you the ability to distribute all those proceeds because often a public company is not going to be willing or able to have some big holdback or escrow. So that benefits the public to private transaction as well. I think Matt touched upon the negotiated indemnity obligations and how do the next page here.
Yep.
How much of a benefit that is, particularly in the private equity transactions, and this is I guess the last point, but it's an important one. It really has affected, I think, the negotiation of a purchase agreement. And as Matt and I were talking before about how, lawyers were initially opposed to this because they thought it was going to eat into their businesses. What are we going to do if we have an insurance policy that covers, all the risk of for a transaction? I mean, why are our clients going to need us? Well, it's had just the opposite effect, particularly on the buy side. It's increased the need for lawyers because on the buy side you're going to have more extensive due diligence. You're going to have an extensive due diligence memorandum that you're going to provide to the underwriter, and you're still going to have to negotiate all the reps and warranties and get comments from the underwriter on the purchase agreement. So it's really it has alleviated some of the negotiations from a purchase agreement, because let's be honest, I'm sure the underwriters, the insurance companies know this, but buyers and sellers, buyers aren't as aggressive with some reps and warranties negotiation of those provisions if they know that they're covered by insurance. And so you have to find there's less negotiation on certain provisions. They're more willing to give you knowledge qualifiers and materiality exceptions in those negotiations, but on the other hand, if the underwriters feel like you've gone too far, they'll come back in and push that back a little bit. But it has changed the way that purchase agreements are negotiated. So here's a sample transaction that shows you the difference between reps and warranties insurance and without a deal with RWI and without RWI, and it shows you the benefits, particularly to the seller from RWI. So in this scenario, you have a $250 million purchase price. You have insurance of $50 million, and by the way, I've worked on deals, and that's sort of a benchmark. But this is a negotiated policy, so you can have more insurance, you can have less insurance. I closed a transaction in February where it was a strategic buyer. The seller wanted a walkaway deal. They were very comfortable with it was a pretty straightforward business. The risk reviewed as small for post-closing claims, and we went with a smaller policy. I was representing the buyer, and then you have 1% of enterprise or sales value as the escrow of $2.5 million. And so, and as we mentioned, sometimes that can be split, or one side can pay it, and the other side or the other side could pay it. And often after a year, that escrow is reduced in half. So that's another benefit and way for the seller to, mitigate their risk. And you'll see that's because most claims are typically made within a year. So the seller takeaways are there's less escrow, less liability, and more cash held back from the transaction. That's a big benefit to the seller.
So this slide, Larry originally called it policy negatives, but I sort of switched the title to make it considerations. So just some things to think about, as opposed to having a traditional escrow indemnification, a transaction, and having insurance in place. Just a couple things to think about, because it is just a different situation than you just have buyer and seller here. You're introducing an insurance company that's really taking the risk and taking this exposure, and they're not getting the benefit of the full purchase price. In the example we gave before, the seller's getting $100 million, they've got the escrow. It's a little different dynamic than shifting all that liability to the insurance company for a nominal premium as compared to the purchase price. So just a couple things to think about. The policies don't cover known issues. There's an actual knowledge exclusion that's sort of the linchpin exclusion of the policy, and that's tasked with maybe 2 or 3 people on the buyer's deal team. It's not the universe of everyone in the buyer's team that's done the diligence. It's not the advisors, but it's probably, business development, maybe 2 or 3 other people that, if they have knowledge of something, they can't just sit back and be quiet about that, close the transaction, and all of a sudden stick that claim to the policy and make a claim there. So what you can't do, which you can do essentially in regular M&A transactions, is you can't just sandbag an issue. We know about this breach, we're not going to bring it up to the seller, we're not going to have it scheduled to the agreement. Once we close, then we'll just bring that breach post-closing. You can't do that in the situation where you have insurance there, because the insurance doesn't want to get hoodwinked into a claim, immediately after the deal closes.
Matt, I sort of compare that to having a fire at your house and then contacting your insurance company for fire insurance. It just doesn't work like that.
Right.
And when you're negotiating the purchase agreement, knowledge can mean items that are disclosed in the due diligence memorandum, items that are scheduled by the seller, and special indemnities that the buyer asks for in the purchase agreement. So those are all ways to sort of smoke out what the known claims could be. Exactly.
And the other thing is you can't simply just rely on the representation from the seller. If the seller makes a representation, we're not aware of any litigation, you may decide not to do any due diligence on that, not do litigation searches, not do lien searches, because that the seller's making that representation, it's supported by the escrow. So if there's a breach and that statement's not right, then you can go after the seller. It's probably not good diligence practices, but you could do that, and so it's kind of a pitfall that we try to advise, prior to us doing an underwriting call, just to make sure that you need to fully due diligence these issues and get comfortable with it. Because what the insurance company wants to do is essentially look over your shoulder and make sure that you've closed out these issues and gotten comfortable with it. So because they're taking that risk that there's not going to be a breach. There are standard exclusions in the policy, as we talked about, any issues that are known to the deal team, any known issues. Those issues might be addressed by specific indemnities. The policies don't cover specific indemnities, so if you had a piece of litigation and you've got a specific indemnity to the seller, you've got an arrangement with the seller, they're going to pay for that if that litigation goes south. Any of those arrangements where you have the direct indemnity with the seller, the insurance company is not going to cover that. Other areas are pension underfunding, asbestos, net operating loss tax credits. On the net operating loss issue, they won't cover prospective utilization of those NOLs. They will cover them if they were used in the past. These policies don't cover sort of forward actions or covenants, which the NOLs fall into that category. And transfer pricing's a sticky issue, and then the purchase price adjustment. You've got the built-in working cap adjustment that you're going to go through 90 days post-closing. The insurance companies expect you to use that to sort of work out the working cap adjustment and not look to the insurance policy. In terms of the process itself, and we'll talk a little bit about the process, but the insurance company goes through their underwriting process, and there may be exclusions in that. When we go out to market to get quotes, there may be a subject matter that may be excluded, an issue that may be hairy. If it's a manufacturing company that's got a lot of environmental exposure, they may have an exclusion for that at the quote stage. Other areas that may be subject matter areas, depending on the risk, may be excluded, but they also may have exclusions during the underwriting process. And those really come in 2 forms. Your tax guys go through the diligence, and it turns out that they weren't paying sales tax in certain jurisdictions. That would be a breach, so therefore that would be something that would be excluded under the policy to the extent it's not scheduled to the agreement as an exception to the tax rep. Other areas where you might see exclusions are areas where you haven't done due diligence. As I said earlier, the market kind of relies on the fact that you've gotten comfortable, you've reviewed an issue, you've run it down. So, so to the extent that, we see this a lot in auctions where, you've got only so much time to prepare for the, put the bid in. The bid goes in on a Monday. There's a lot of pressure. There's other bidders out there, and the deals of the dynamics of the M&A are that they want you to sign on a Wednesday. You may not have had time to look at, foreign tax exposures, and so you may not have done diligence on that, noting that your eye on the prize is just try to win the transaction in the bid format. So if you didn't do diligence on a topic matter, the insurance company can't accept that risk, and they will put an exclusion there for something that you haven't done due diligence on. But there's some workarounds that we can do to address that. What we can do is put the policy in place, have an exclusion not for all of tax, but for sales tax relating to international sales or international tax. And then we can bracket that exclusion as a conditional exclusion to allow you to provide additional due diligence post-signing, and if those results come back favorably, go back to the insurance company, talk to them about review, and then have that exclusion removed. So that gives you another opportunity to get rid of the exclusion as long as you've done the due diligence and the diligence has proven that there's no issues there on that subject matter. The other thing is, and I alluded to it earlier, is that the market is insuring, the insurance market is insuring the representations and warranties in those agreements. If you had a walkaway deal with a seller doesn't have indemnity, and you've got a buyer who's negotiating the purchase agreement, maybe the seller's counsel is not so, nitpicky about how they're fighting back in terms of how those representations and warranties are worded. The market throughout the process, whether it's at the quote stage, during the underwriting stage, and up until signing, they sign off on every version of that purchase agreement. So to the extent that those reps get weighted too heavily in favor of the buyer, they may push back on certain areas, and it doesn't mean you change your purchase agreement, but they may deem certain things as amendments within the policy. So a lot of things relating to, examples of knowledge qualification, they may require, a written qualification in terms of notices, if there's anything that's covenant related or so forth, that they'll have those as deemed amendments into the policies themselves. So you don't just have free rein to just try to make that purchase agreement as broad as possible. You've got the insurance company that's going to keep you in check, so to speak, in the process to make sure it's not weighted too heavily in favor of the buyer. Another point just to recognize is it's covering, as it says, the title of the policy is representations and warranty insurance. So things like covenants, specific indemnities, those issues aren't covered on these policies, but you would likely have those as indemnifications within the agreement as agreed with buyer and seller. The other next point is just an obvious one. There's a premium associated with it. There's a retention associated with it. It's about 1% of enterprise value purchase price. That all said, there is a basket, in traditional M&A transactions where, buyer can't go to seller for $1. It usually has to hit some kind of threshold, so you're not arguing over, the minutia there. And then another thing to think about is just different scenarios. We talked a little bit about auctions. In an auction scenario, especially if you're bidding against private equity firms, your best way to position yourself is to really try to put, not have the seller have any limitations there. So a lot of times it'll be a walk-away transaction where the seller won't have any participation within the retention. It'll be solely the responsibility of the buyer to try to really provide a clean exit, and that just tries to make your bid look more attractive than others. So if you're bidding with private equity firms, that's the way they're going to structure it. If you're in an exclusive situation where it's just you and you line up well with a strategic acquisition, you've got a little bit more leeway there. I often recommend that what you're really doing is if a seller comes to you and says, we want you to put rep and warranty insurance in place, you're really alleviating them from the obligation of putting up an escrow, alleviating them from having to have an indemnity obligation that'll go out multiple years. So you may be happy to do that for them, but in exchange for that, if you can do it in your deal negotiations, negotiate an indemnification that sits behind the insurance. So in the event that you have an exclusion at the quote stage, or an exclusion that comes up during underwriting, or in the unlikely event that there's a claim and it's not paid, the insurance goes first, but then you have the indemnity that sits behind the insurance, so you as buyer have the best of both worlds. So just something to think about as you're positioning yourself in transactions in terms of how you might use the insurance in an auction versus a strategic situation.
Yeah. Thank you, Matt. I think I wanted to mention just briefly about, for those of you who haven't been heavily involved in an auction, how that works typically. And I think they vary based upon the size of the deal and who the buyers and sellers are. But typically the seller will set up a data room with due diligence uploaded, and then you'll receive a form purchase agreement. So as a buyer, how you participate in the auction is you will basically submit a purchase agreement and a purchase price, and as your goal as a buyer is obviously to have, well, your goal is to be protected, but to win the bid, your goal is to hopefully have as few changes to the purchase agreement. Obviously, you want the best price because that's, at the end of the day, that's what's going to usually carry the day, but you also want to have as few changes as possible to the purchase agreement. And so what reps and warranty insurance does is, as we've discussed, it allows you to really return a pretty clean draft of the purchase agreement to the seller. I also want to mention, as one of the exclusions that we have on here, as Matt's mentioned, is the PPP loans, and so those are largely, I think those have for the most part been forgiven and gone away, and I don't know if the policies are ever going to change, but I did have a transaction where the night before closing, the Small Business Administration came out with an announcement that basically said that the buyer of a company can be liable for the PPP loan if it's not forgiven. And so those of you who were familiar with PPP loans realize that, no surprise, but at the beginning of the process, depending on who your lender was, it was sometimes very difficult to get to have the loan forgiven. And so we had a seller that was that had a PP loan out. They had filed their application and were waiting forever it was a rather large financial institution to come back and confirm that their PPP loan was forgiven. The buyer came in and said, well, guess what? We're not going to assume that liability, so you need to, and we won't take a special indemnity. You're just going to need to pay off that loan. And our client agreed to do that. The buyer made some other concessions, but it was unfortunate. And I think most of those loans, I think that exclusion will go away just because PPP loans will either be repaid or, I think all of them by now have probably either been repaid or forgiven. So not an issue going forward. This is the state of the market, and as we've mentioned, this is the reps and warranties insurance market has exploded over the last 5 years. Matt was telling me before when this product first came out in, what was it, the early 2000, he was you felt like sort of like a snake oil salesman, didn't you? He was not very popular, and people didn't want to talk to him at the cocktail hours or receptions or take his calls. But now Matt has gone from the least popular guy at these meetings to the most popular guy because everybody is familiar with reps and warranties insurance and wants to have it for their transactions. So, and I think this also affects in-house counsel in the sense that a lot of times your companies will have relationships, like for example with Marsh, and this has been an experience that Matt and I had. We had a buy-side transaction. Marsh was is their broker, and so they used Marsh for the relationship, and in-house counsel actually helped internally with the process of providing Marsh with what they needed from the client's perspective to underwrite the transaction. So this does affect in-house counsel as well. Sometimes you'll get involved from a relationship standpoint with your broker and their insurance company. But so anyway, as I think one of the takeaways is reps and warranties insurance is very popular now. I would say it's, you never say never, but I think it's here to stay, and it's only going to grow in popularity. As you can see, this has taken off so fast and you have so many players involved that the data is just now, I mean, the data is just now coming in. So a lot of what we talk about are estimates based upon information that's out there, but it's still like the fourth quarter of last year was crazy, crazy busy from a deal standpoint, from a reps and warranty standpoint. In fact, I had a transaction. We went out to market. I think it was the deal we worked on together in December, and the bids came back, and sometimes you couldn't even get on deals. You couldn't even get a quote because there was such a strain on human capital. And so we weren't going to, the deal got postponed for other reasons, so we went back out to the market in January and had much more, better pricing, more responsive underwriters, and it was.
Yeah, I mean, just for perspective, we look at the graphs of the deals that we've done. And Marsh did 1,000, we closed 1,000 transactions last year. I worked on 85 transactions. The universe of all the transactions insured the U.S. was about 4,000. Back in the 2000s, we might have been do 10 or 15. And so there are a lot of markets, insurance markets out there that provide this coverage. They're fully staffed, but last year was record numbers in terms of M&A activity, and so as we got to the fourth quarter, insurance rates come up and come down, and usually it's driven by claims. This was kind of a unique situation where it was just, we joke about it, it's kind of surge pricing on getting an Uber, when you're leaving, the concert or the Cowboys game. But, so pricing came up just because you just didn't have a lot of availability to actually do the transactions, and then you have certain outside counsel that represent these markets, and they could only have so much capacity to help and underwrite transactions. So markets got very particular. Prices came up. The easier risks were easier to insure. The challenging risks were more challenging to insure, and so there was sort of a logjam there. I mean, that's eased off dramatically. We've had M&A activity in the first quarter has been a lot slower than that, but anyway, that was what was driving some of the
I think,
business.
Matt, you mentioned that reps and warranties insurance was it 25% of Marsh's?
Yeah, I mean, it was from an income standpoint, it was a huge driver of Marsh's revenue for last year as well.
Right, and because it's a huge driver last year, I think insurance companies, and brokerage firms are focused on this market and have big expectations and large amounts of capital and budget set aside to grow the business. Is that what you're seeing?
Yeah, I mean, because of AIG, Chubb, all the others. I mean, they've got budgets, and so you've got. I mean, it's unlike other traditional insurance policies that renew. These policies don't renew. So as they've had success in the last year, with the slowdown of the M&A activity, they've got to fill that bucket up again. So recognizing that they've got to, grab more market share, it's just put a lot of pressure on them to try to be more competitive on rates, to try to grab opportunities, and so that's worked more in our favor, and things have gotten a little bit, lean our way as opposed to the insurance market's way in terms of them.
So from a customer standpoint, I think we can expect maybe, compared to certainly the fourth quarter of 2021, that pricing will be, maybe come down a little bit, and you'll get more attention from your relationships and the underwriter as far as reps and warranties insurance, because people, more resources are being devoted to this product.
Exactly.
I also want to mention, go back just a little bit, I'm sorry, but many times these exclusions that you'll have on these policies, in order for the seller not to have those risks, you can insure around those policies. So they're common. I always tell clients that a lot of these risks that you have are, risks that you have even if you don't sell the business. So you're already aware of these risks, and you're already providing for them with D&O insurance, which would include, employer's liability insurance. You'll get cyber insurance, and you'll have. What else is out there? You get D&O, cyber, products liability. You can even have environmental insurance. So a lot of these risks that you're really concerned about, you're already insuring around those. So if they're excluded, you don't really care as much because you have a policy. Mm-hmm. And depending on who the buyer is, they would likely get an endorsement on their policy or cover those post-closing risks. And if they can't do that, what we've seen quite a bit is the seller and the buyer will work together to obtain a tail policy to cover those risks after closing. And frequently, if I'm representing the seller, or even if I represent the buyer, we'll agree to split those costs because it's sort of a supplement to the reps and warranties insurance.
Yeah, so this just outlines some of the hot spots of some of the things that come up as issues. And you're not going to see an exclusion for these after, when you get into underwriting. But if you go out with a really high-tech company that's got a lot of tech exposure or cyber or collects a lot of personal identifiable information, the market recognizes that, there's a lot of risk inherent with that target. And so there's a couple ways that they may address it. They may have an exclusion for that and say, we're not going to cover cybersecurity data privacy. That's not the best scenario for you, but as Larry alluded to, that target likely has a cyber policy in place to address those exposures. You're probably going to have the target have that policy go into runoff, so you've got a traditional policy to cover those exposures, which may not be covered under the rep and warranty policy. It's not the best fit because the rep itself, it speaks to those exposures and talks about IP technology and so forth and so on, is very broad in nature. It's negotiated. It's designed to capture, a broader basket of exposure than you might have in the insurance policy. So we'd like to avoid the exclusion, but if we do have an exclusion, then you probably have a traditional policy to cover it. Sort of a middle ground is the rep and warranty policy may say, we'll cover cyber breaches, but we're only going to follow the terms and conditions of the underlying cyber insurance. So to the extent the cyber insurance policy has an exclusion for that claim, the rep and warranty policy is not going to cover that claim because they look at that as a cyber insurance markets know better than they do about what the exposures are inherent in a certain target, and they underwrite them with cyber experts. So they're saying there's a lot of exposure here. We're not the experts. We'll provide coverage, but we only want to provide coverage in excess of what the terms and conditions are of the underlying cyber policy. So it may be excluded. You may have that kind of middle ground where it's not excluded, but it's following the terms and conditions of an underlying cyber policy, and that's how they address those sort of hot spot topics on those exposures. The other thing to mention just also is that obviously we do policies for transactions for all over the globe. In addition to certain topic matters that may be concerning to some of the markets. Some jurisdictions are more concerning than others. It's not to say that we can't do policies. We do policies all over the globe, but like Brazil is a challenge for issues of labor and benefit laws and tax laws, and so that's a little bit more challenging. Eastern Europe, obviously Russia, Ukraine's a problem right now. And some of the Asian jurisdictions. Again, when we point out these are more challenging issues, it's not to say that we can't insure them. It's just to say that if you go out to 22 insurance markets, you're probably not going to get 22 quotes back. You're going to get some that are a little bit leery about the jurisdictions. And then just talking about pricing, this just gives you an idea back to, I guess, it was 2015, just give you an idea about this is cost as it relates to the limits of liability. So if you were to buy a $10 million policy in 2021, the cost of that policy would cost $427,000. It's a one-time premium. It lasts for the duration of the policy period, and it just gives you an idea of where we are on pricing. It's a little deceiving because these are based on when the transaction closed. So, you get the quote, it's probably 60 days before the transaction closed. It's advance of signing. So let's say you get a quote, 3 weeks later, policies put in place at signing. Another month later, you go through HRSR, get those approval, the transaction closes. So these metrics are based on when the policy's closed, and 4.27% is the cost for the policies for 2021. We were seeing rates in the 6 to 7% range in the fourth quarter. And 2022 shows 5.48%, but again, you're capturing a lot of policies that were quoted in the first quarter that actually didn't close until the first quarter. The quotes, if you go out now, we're seeing the rates at about 4.5% as a percentage of the limit of liability.
And Matt, is that a fair statement that the larger the deal, do you see the percentage going down?
Yes.
On a percentage
Yeah,
basis?
I mean, a fundamental concept is if you have if you've got a $10 million policy, there's a lot more risk within that 10. If you've got a $100 million program, the rates drop down as you get higher up because, you know, the top 25 of insurance is less risky than the first 25. It looks like we're running pretty close to time here, but I just want to run quickly through the process for how we put the insurance in place. In order to get quotes, we need a draft of the purchase agreement. It can be an auction draft. It can be a very early rough draft. Audited financials for the target, and then either a management presentation, a SIM, or some other kind of business description. Within 3 business days, we can come back to you with quotes. We're going to outline the costs, the retention, any exclusions, an area we call heightened risk, which is just to say that it's not excluded, but you know, if there's a lot of exposure relating to misclassification of employees or cyber or what have you, the markets are just putting you on notice to say that this is something they're going to expect wholesome diligence on. And then the process to put the policies in place, it's about a 5 business day process. That starts when you have your diligence reports and when you have schedules to the agreement. And just the comment on the diligence reports, all markets can work with third-party diligence reports covering legal, tax, financial. You know, they're also going to want to see a review of intellectual property, labor benefits. So private equity firms will have reports for all those subject matters by third parties. Strategic acquirers often do those analysis and diligence internally, and there are markets that are more nimble than others working with internal diligence, and all we would expect is to have some kind of written memorialization that will outline that review and findings, because the insurance market's not doing their own independent due diligence. They're really doing an audit or looking over your shoulder. But just to think about that, because you know, understanding you guys are mostly strategic buyers, we can do transactions where the diligence is going to be done internally. So through underwriting process, they'll review those reports. We'll set up an underwriting call. That underwriting call is about 2 hours. There'll be an agenda that'll outline it. It's you know, you call it an audit or review, but it's a friendly discussion. It's the insurance market and their outside counsel that's going to, you know, we're very well versed in diligence practices, and you know, we talk about a half an hour, 15 minutes or so about the background of the transaction, and then we have specific times for subject matters of legal, financial, tax, IPIT, environmental, labor benefits, and you know, the person or the advisors that worked on those various disciplines, they dive in for that predetermined time to talk about their subject matter. So you don't have Deloitte tax sitting on a 2-hour call. You have the person that addressed those subject matters drop in for that discussion. After that discussion, we'll have a list of follow-up questions that are either issues that you couldn't answer because you didn't have it readily available on the call, or there may be questions on issues that you didn't get to in due diligence. We'll have an ability to answer those questions, close those out, and then we have a policy draft, and the policy draft is typically based on a precedent that your outside counsel's used with that insurance company in the past. So we're not starting from ground zero on that negotiation of the policy. It's already been negotiated, but obviously it's going to be fine-tuned to your transaction, and the person that you're working with, the partner you're working with, your outside counsel is probably going to want to fine-tune that policy. And then through that process, as I said earlier, they sign off on each update to the purchase agreement and the schedules, and then we put the policy in place at the time the transaction signs.
Yeah, I just want to, thanks, Matt. I just want to say from a deal perspective, I would say reps and warranties insurance has become one of the larger pacing items in a transaction. You have to make sure your closing and the closing mechanics are coordinated with the issuance of the reps and warranties insurance policy. I'd say it's right up there with third-party consents and HSR approval or the waiting period. So it just becomes, it's a big pacing item, and we need to make sure that the policy's in place when we close.
So we've got a few more slides here, but maybe we just want to open up to any questions.
I want to, yeah, let me mention one. Just let me go through to maybe page 14 real quick. I just want to mention two things here real quick. One is important part of the policy, and typically when Matt gives you the, or when the underwriter gives you the policy, they're going to have this in there, but you want to make sure it's in there. It's waiver of subrogation. Typically an insurance policy provides that when they pay a claim, they are subrogated to the rights of the insured to go after a third party. And so the last thing you want is as a seller, is for the buyer to make a claim on the policy and then the insurance company to turn around and ask you for money. So that's I think that's always a give by the underwriting company. You also want to make sure they don't come back, waive subrogation or claims against any of your key customers, or suppliers. In other words, a strategic relationship. You don't want to have a claim come up, but, with one of your big customers and have the insurance company go after them after they've paid the claim. I think the other thing, before we open it up, Matt, I just want to cover real quick the claim process. I think we have a couple of slides that show there are claims out there. I think that data is still being developed. I think the insurance industry definitely wants you to be aware that there are claims out there, and then there's a reason to buy their policies. If there were never any claims, and obviously buyers and sellers would be less hesitant. They'd be more hesitant, to purchase policies. So there is an inherent reason why, I don't know if they want them to have, insurance companies don't want claims, but they definitely want you to be aware of what's out there.
Yeah, it's not like D&O insurance, property insurance, where you buy those coverages and you feel like you have to buy them for your. If these policies have a reputation that they're not paying claims, then people will go back to the traditional escrows and indemnities. So they know they have to work. The third-party claims are a little bit more black or white, so to speak. It's easy to determine if there's a breach, and it's easy to determine if the IRS comes back and says you owe $10 million in this tax issue, what the value of that is. The ones that get a little bit more tricky are the first-party claims, whether they're financial statements, inventory. One thing to note is these policies don't have an excluded for multiplied damages, so to the extent you're paying 10 times EBITDA, they're not going to give you an affirmation that that's how the claim is going to get paid out. But if you have an EBITDA loss, like a lost customer, we would submit that claim and argue that there should be a multiple applied to that loss. So it's not just a loss of $1 million relating to that relationship, but you paid 10 times, and that customer would be there presumably over time. You're not going to have it in perpetuity, but that's that process itself just takes a little bit more time to work through.
Thank you, Matt.
Yeah, next slide just gives you an idea where we're seeing claims and the timing of those claims. Most of the claims come in within a year. And then this is just sort of a leave behind. Neither Larry or I are tax experts, but just some tax considerations to think about, in terms of how the premiums and so forth.
And basically the takeaway from that is that, by the way, most presentations you should end with on a high note. We didn't do that because we have tax considerations last. But the point is that what you want is the cost of the policy is usually capitalized and amortized as part of the purchase price. And if there's a claim, you want, I think particularly the seller, you want that as an adjustment to purchase price, and so does the buyer. They don't want that as income. They want it as an adjustment to purchase price. So I think that's it, Matt.
Yeah.
So any questions? And if you ask questions that we know the answers to, you get an extra little thing of cookies.
Yeah. No,
Hey guys, I didn't do this. Can you repeat the question for the folks online? Because they couldn't hear the question.
So I guess the question was, how does the action loss exclusion work, and how does that interplay work with the attorneys that are advising the client, and sort of the interplay with the diligence memos and so forth and so on. There's a representation in the policy, so to speak, or a statement, certification that the market has received all the diligence reports, whether those internal, and they're formal internal, and not just the emails going back and forth, and the diligence materials. So they see all that information there, so they get a sense of what the actual knowledge universe is. If someone says, oh, we did a review of, employee classification, and we saw that these titles were misclassified, or, we should have been paying overtime to those folks, they'll see that within the correspondence, and they have the opportunity to ask those questions during the underwriting process. So it's a pretty well understood universe of what the knowledge of the issues that are available. The actual knowledge is not tasked to outside counsel. Larry would never let us have him sign a statement saying that he's not aware of any actual knowledge, because he doesn't want to be responsible for tripping up the policy and having that exclusion. So it's internal folks, and again, it's about 3 people. We call it the due diligence, or the deal team members. And so to the extent that they know of something that and it's literally, do these 3 people have any actual knowledge of a breach? It's not constructive. It's not, this document in the data room is here. this person should have known that, so A plus B should, she should have known C. So it's very well defined, and it's just actual knowledge of an actual breach.
And typically, as you can imagine from a buy side, by the way, it's a good question, and it's still developing because as claims are made, we're going to have to see how insurance companies handle those and whether insurance companies, I always say they're way better at collecting premiums than they are at paying claims. And so we'll have to see how some of those claims are handled. But as far as the deal part of it goes, there are a lot of issues that are raised from a buyer's perspective on due diligence, but only a few of those actually make their way into the agreement as far as being actual known claims. And usually those will be reflected by a special indemnity, and the insurance company will pick that up and have that excluded from the policy. I'm not used to seeing, well, I guess it does happen, but usually the buyer's counsel highlights those known claims, and they are highlighted in the purchase agreement, and then the insurance company will pick those up and exclude those from the policy. That's usually how it works.
The actual knowledge issue and the exclusion itself, it's a moral hazard guardrail. They just don't want to be set up for a claim, and it rarely gets invoked to an exclusion in terms of when we work out claims. The situation where we've seen it, it's borderline fraud. So you've really got to have a smoking gun and someone really intentionally trying to deceive the insurance. Yeah, and the same goes with subrogation, another moral hazard guardrail. In reality, we don't see people subrogating against sellers for fraud. They only have the right to subrogate for fraud, but it's just to make sure that everyone sort of keeps their honest hat on during the process.
Thank you.